Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. My name is Riffat Hussain and I'm your host for the next hour. As our viewers will be aware, this is a free legal advice show which enables you to present your legal questions within the English and Welsh jurisdiction and receive answers in respect of those problems. You can send your questions through in two ways. Firstly, by contacting me live in the studio and speaking to me directly with your question. Alternatively, if you prefer to remain anonymous, you can send your question through WhatsApp and I will read through the message and give you an answer. Both of those numbers can be found at the bottom of your screen. I do have a number of questions that I have received already, but before I proceed to those, just to kind of elaborate on the purpose of this show. The purpose is to answer any legal questions that you may have and are wanting to receive some kind of guidance or even answers to those questions. Some of the questions may be fairly straightforward and I can therefore address them immediately this evening. Some questions, however, may require a more in-depth consideration, some further analysis before an answer can be given. In those circumstances, I will arrange for our team to take your number and will contact you after the show so that I can take the detail and provide you with the answer that you required. As always, the responses are free and that extends to any contact that I would then have after the show if further elaboration is needed. Moving on to the questions that I have this evening. The first question I have is, my uncle is 85 years old. He's divorced. He went to Pakistan in 2018 and got married to a 35-year-old lady. He has 3 children who he would like to bring back to the UK. The question is, how can he call his second wife over? He divorced his first wife in 1990. Now, so the question is in relation to an immigration matter. This gentleman has visited Pakistan and married for a second time. He's already divorced. And the question is, what are the requirements essentially for him to invite his second wife to the United Kingdom to join him here? Reading the question, I believe the concern may be around the fact that he is divorced already and had a first wife previously. But the questioner does say that marriage ended with a divorce in 1990. In terms of the immigration rules, there are a number of requirements that need to be satisfied, both in relation to the relationship, but also in respect of any financial criteria as well. So in respect of the relationship, the applicant will need to show that they are married, that they have met their partner, and it's a lawful marriage in the country that it took place, i.e. in Pakistan. That could be fairly easily satisfied in terms of the requirement by providing a marriage certificate, any photographs from the marriage, things of that nature will satisfy that requirement fairly easily. There is, however, a requirement that any previous marriages or relationships have ended. And in this particular case, therefore, the applicant will need to provide a divorce certificate to show that they were free to marry when they did marry. It sounds like the 85-year-old uncle is based in the United Kingdom, and therefore a English divorce certificate will be needed to demonstrate that marriage has in fact ended, and therefore he was free to marry at the time he did. There are financial requirements, as is commonly known now under immigration rules, namely that the applicant, if he's inviting just his wife, will need to demonstrate that he has an income of 18,600 gross per annum. Judging from the age of this gentleman, it's unlikely that he is in employment and therefore receiving a salary. There are other ways of satisfying this requirement, namely through savings or other other non-employment income. Alternatively, there is an exemption from this financial requirement in respect of the 18,600, and that is if an individual is receiving certain public fund benefits, such as disability benefits, carers allowance. Unfortunately, universal credit does not count, and pension does not count as well. So it would be worth looking at the rules to see if the income requirements are therefore satisfied. There is also a requirement that there is adequate accommodation, namely that there is at least a bedroom in the house, which would be for the exclusive use of the applicant and her husband. So that's a broad overview in respect of the requirements. I suspect the question was more geared towards the fact that uncle is divorced and what the requirement around that would be. And I believe I've answered that. If I haven't, then please get in touch, either by calling the telephone number at the bottom of your screen or sending a follow-up message through WhatsApp, and I will address that further for you. Moving on to the next question. This again is, I am a Pakistani and I have a biometric residence permit on the 10-year route. Would you kindly explain if there is any changes the government has made to biometric residence permits due to Brexit or COVID-19 in the last 2 years? I'm not entirely sure that I understand the question. So please do either call in or send some further details through WhatsApp. The question again is an immigration-related question. The questioner is on a 10-year route to settlement. Usually this is a route under the private and family life route, where either the applicant has been granted because they have an accepted family life which cannot continue outside of the UK. They may have children, for instance, who are British citizens, or children who have been resident in the United Kingdom for a period of 7 years or more, and therefore are what we call qualified children under the immigration rules. Such an applicant will usually be granted a 10-year route to settlement with a renewal period of 2.5 years until that 10-year period is completed. At that point, the individual in question would then apply for indefinite leave to remain. With regards to changes made by the government in the last 2 years, there have been changes, but none that would change the process that you follow in respect of the 10-year route, and you would still settle within or after the 10-year period. So I do hope that that does answer your question. So just to, there are a number of questions in relation to this family route. So I will just provide some further details in respect of that. I've touched upon it already. This is a route for individuals who would qualify under the immigration rules, usually as a partner or a parent. The partner route can be somewhat troublesome in the sense that there is a requirement to show that the relationship cannot continue outside of the UK. And where it is just a couple, either a British couple or one party is settled in the United Kingdom and the other party is either has no permission or is a migrant who is then required to leave, the Home Office will then consider whether or not they can both leave together. The problem with the partner route is usually most adults will make an informed decision. And the way that the Home Office and the courts have interpreted such a scenario is that if a party willingly enters a relationship with an individual who has no status and is required to leave the UK, then they should either be willing to leave with them or end that relationship because they are consenting adults. The situation is slightly different where children are part of that relationship and that scenario because they don't make that informed consent. So I hope that answers some of your questions. In respect of a further question, we have someone marries an overstayer and they have documents and they have, not had a pending case at the Home Office. What will be the consequence? Again, I think it touches upon the scenarios that I was just describing. You have an individual here who is an overstayer. It says they are married. It's unclear whether that's a marriage under English law or whether this is another religious marriage. If they are, the question is, are there any consequences if they don't have a pending application? Well, the overstayer is liable to detention and removal from the United Kingdom, that they're in a particularly precarious situation. And so the advice always is regularise your status as quickly as possible to prevent that from happening to you, to prevent you from ending up in immigration detention, and then the Home Office enforcing removal. It's easier to get legal advice whilst you are in a position where you can go and do that, to have an application properly prepared for you with proper assistance, which again is not always possible if you have been detained and are facing imminent removal. It's not clear whether the questioner is asking about consequences for themselves or for the overstayer. I mean, in terms of overstayers, there's no right to rent, no right to reside. They don't have bank accounts, they're not allowed to work, so there are quite serious consequences for them. We are going to go for a short break. Please continue to send your questions through. As I say, please feel free to call me directly in the studio or send through your messages on WhatsApp, and I will answer them on the other side of this upcoming break. Assalamu alaikum and welcome back to the free legal show on British Muslim TV. I am your host Riffat Hussain. Thank you as always for sending through your questions, which I have tried to get through as thoroughly as I possibly can. If I do miss anything, then please do follow that up with either another message or by calling through directly on the number at the bottom of your screen, and I can then elaborate further on the questions that you pose. With regards to the questions that have come through, I was just finishing off in respect of a question about an overstayer who has married in the United Kingdom and the consequences that they may face. I did get through a significant part of that, but again, if I could just reiterate that it is important that you do seek early legal intervention so that you can regularise your status as soon as possible. As I say, the consequences are that you are constantly trying to evade the authorities, unable to work and access vital services that you may need to. And any application that you make at a point of detention is always weaker than an application that you make yourself. So do bear that in mind. And I hope that does answer your question. If I've missed anything, then please feel free to contact me either in the studio or by sending a follow-up message through WhatsApp. Just on that final point, I failed to mention that it does mention that this individual is married. I did touch upon this prior to the break. It's unclear how they are married, whether it's a lawful marriage under English law or whether it's a religious marriage that's not recognised under English law. So it may be that the individual thinks that they're married and they are in fact married under religious custom or some other custom, but they are in fact not recognised as a married couple within the United Kingdom because it's not a lawful marriage. So that I hope that does answer the questions that you presented. Moving on to another question. So the questioner asks in respect of visit visas to the United Kingdom, and in particular the documentary evidence required for a successful visit. Visit visas are one of those areas where there is a high level of refusal, and usually this is because that there is no right of appeal. The only way a refusal of a visit visa can be challenged is through judicial review, which can be costly and have lots of legal implications. And usually most people find that it's cheaper to just reapply. However, a negative decision does remain on the individual's record, and that can present problems in itself. It's always therefore advisable, to have a well-prepared, well-evidenced and documented application to start with, so that you don't get into this cycle of refusals that happens, unfortunately, far too often. With regards to the requirements for a visit visa, an individual needs to show that they are genuinely here for a visit. That could be for a number of reasons. It could be a family visit. It could just generally be a tourist visit. So that could the reason is not necessarily the thing that the entry clearance officer would be looking for. Is whether or not you demonstrate that the reason you have given, you are genuine in that, and that you do intend to leave the United Kingdom after the period that you have specified. Again, they can be quite difficult, because how does one demonstrate their intention? How do you say, well, I am telling the truth, and enable the entry clearance officer to believe? The main thing is to show ties to your country. What is it that you will be going back to? So young men generally who are fit and healthy and have little in their country of origin are often refused, because the Home Office will say, well, there's no incentive for you to return. Again, it's advisable to seek legal advice, at least have your application checked before it's submitted, just to ensure that you've been as thorough as you can do in trying to persuade an entry clearance manager that this is a genuine visit, and so that it will not be refused. Moving on, I have another question. Says, Salam sister, wa alaikum assalam. Uncle has 3 children. Right, okay, so I think this is a follow-up from the question I asked earlier. I answered earlier even, in respect of the uncle who has married a second time in Pakistan and is seeking to bring his wife to the United Kingdom. It says the uncle has already brought 3 of the children who he has with this new wife to the United Kingdom. So the question is, can the children invite their parent to the United Kingdom? Are there any other options other than uncle inviting his new wife to the UK? I'll come back to that just in a moment, because I have a few more questions that I'd like to touch upon first. The next question is, I separated from my husband after a toxic relationship. He refused a talaq and divorce. He moved, I'm sorry, there's an abbreviation that I'm not sure of, but has moved since and remarried. Sorry, I think he's moved to Bangladesh. He's moved to Bangladesh since and remarried. Under Bangladesh law, it is a criminal offence to marry without consent. It has been 2 years plus. He is still a Bangladesh national. There has been a lot of deception. However, I am unable to travel to Bangladesh to get justice, as I put myself at risk. Don't have funds and have 4 children. Me and my children have suffered at his hands, and I wasn't mentally fit formally. and also scared. I want justice. What can and should I do? There's additional information. I was just going to say that's probably not a detailed enough question for me to answer, but we endured abuse at his hands for 23 years and safeguarding issues too. He's never worked and left us stranded. Can his visa be revoked? Unfortunately, sister, I'm not able to answer that question for you, simply because I don't know what the question is. With regards to Bangladeshi law and him committing a criminal offence under Bangladeshi law, then I'm not a Bangladeshi lawyer, unfortunately, and I'm not familiar with that jurisdiction. So that's something that I definitely cannot comment on. With regards to your question, or certainly the information that you're personally unable to travel to Bangladesh due to the risk, your financial circumstances and your commitments to your children, then there may be a way around that if you're able to contact a Bangladeshi lawyer who may be able to advise and assist you further whilst you remain in the UK. But it's certainly not within my expertise or my competence to address that for you. You do ask a question that may be within my competence and expertise, and that's whether or not his UK visa can be revoked. If you could just send me some more information about what type of visa he has in the United Kingdom, I will then be able to address that for you. But as the question stands, unfortunately, I don't have sufficient information to give you an answer at this point. But certainly with regards to the Bangladeshi law, try and see if you can contact a Bangladeshi lawyer to seek some further assistance with regards to that. So just as a reminder, following on from that, the areas that I can deal with, although broad fields within legal fields, so I can deal with employment law, criminal law, family law, certainly immigration law, it does need to be English law based. I don't practice in any other jurisdiction, and unfortunately do not have experience in any other jurisdiction. So please remember that when sending through your questions with regards to foreign jurisdiction. We have another message which I will move on to whilst we are waiting for some further information. Right, I believe this may be our sister again with some further information, and she confirms that the husband has indefinite leave to remain. Can it be revoked? Indefinite leave to remain usually can only be revoked where it's either been obtained by deception, and I know that you say that you've suffered deception, but it certainly was a valid marriage and a subsisting relationship, presumably for the duration that you were applying for him to remain in the United Kingdom. Demonstrating that it was a deception to obtain his leave in the United Kingdom may prove to be difficult for you. Other circumstances where indefinite leave to remain can be revoked is where there are criminal convictions within the United Kingdom that would then lead the Home Office to pursuing legal action and deportation action to revoke any kind of indefinite leave to remain and remove the individual. Again, there doesn't appear to be, on the face of it, from the questions that you, or from the information that you presented, any criminal offences, and therefore the situation is rather complex. That's quite clear. It's clearly a lengthy marriage, lots of issues in terms of safeguarding. You mentioned there are children in the relationship. You may be better off speaking to a local legal aid solicitor who's able to give you free initial advice and certainly some guidance as to the right direction you can go in, having looked at some of your paperwork as well. But again, with the information I have, unfortunately, it seems that there is little that can be done in terms of revoking your husband's status in the United Kingdom. We are just heading towards a short break. Before I do head off, I do have a number of questions to come back to, but please do carry on sending your questions through. As always, you can ring me in the studio on the number, the landline number, which you find at the bottom of your screen, and I will speak to you directly. Alternatively, if you do wish to remain anonymous, then please feel free to type out your message and send it through on the WhatsApp number also at the bottom of your screen. Please do try and provide sufficient information, and I will see you on the other side of this break. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I am Riffat Hussain and I continue to be your host for the remainder of this show. Just before we went to the break, I was addressing a question from one of our sisters who unfortunately found herself in an abusive and toxic relationship which later broke down, and she is seeking to ask whether there is a way she can apply for her former husband's leave to remain in the United Kingdom to be revoked. Sister is quite anxious to get justice in this matter, as she feels that she's been deceived into bringing this gentleman to the United Kingdom, and feels that that justice would result if his leave was revoked and he was returned or he remained in Bangladesh outside of the UK. Unfortunately, sister, I do see your follow-up response in that you brought him to the United Kingdom, and I appreciate that. But at the time, you were in a subsisting spousal relationship and you met the rules under the immigration rules. The Home Office was thus satisfied that this was a genuine subsisting relationship, and your husband was granted leave accordingly. Unfortunately, that marriage has broken down. 2 decades later, broken down. It's highly unlikely that the Home Office will revisit that decision, as aggrieved as you feel, because it cannot, as I say, unless there is very clear evidence of deception, as opposed to the fact that this marriage has now just broken down, albeit in very difficult circumstances. But it's unlikely that his leave will be revoked unless the circumstances I mentioned prior to the break do apply. I did move on from a question earlier, which was in respect of our 85-year-old uncle who has remarried in Pakistan and is seeking to bring his second wife to the United Kingdom. I addressed the requirements with regards to the spouse route prior to my earlier breaks, but the questioner has followed up with some further information and another question, so thank you so much for that. The questioner adds, uncle has 3 children with this new wife who are now in the United Kingdom. Can the uncle's children call their mother over? So there are provisions within the immigration rules which allow for a parent to join children in the United Kingdom. However, the children or the parent can only rely on the children sponsoring her if they do not, or if she does not meet the requirements for the partner route. And therefore, because she, or she's not in a relationship, forgive me, not just that she doesn't meet the rules, but she's not actually in a relationship with the other parent of these children. Obviously, that's not the situation here. This lady is in a relationship with the father of these 3 children, and therefore she would need to come through the spouse route and cannot rely on the children in that situation. So I'm so sorry, I know that that's probably not the answer that you're looking for, but she wouldn't qualify under the immigration rules as a parent of children simply because she is able to apply under the partner rule. And I appreciate that they may not meet the requirements, certainly in terms of the financial requirements, but that does not allow her to rely on the children in the UK. I've got another question which I'll move on to. So my husband is in Pakistan, he's been refused a visit visa and is banned for 10 years. I want to sponsor him. I can't work because my youngest daughter is visually impaired and I am on benefits. Can you tell me how I can sponsor my husband and what should I have to do? I have 2 more girls. Also, I have been here since 10 years in the UK. I have been married since 14 years. We are all British citizens. So again, an immigration-related question. Our sister is in the United Kingdom, a British citizen, and she has 3 daughters with her husband. Husband is in Pakistan and he's been refused a visit visa with a ban for 10 years. It's unclear why he's been refused, or certainly why he's been banned for 10 years, but also why it was simply a visit visa he's applying for and why that has been refused. Generally, if it is a visit visa, and I touched upon this earlier in the programme, the entry clearance officer will look at the intention and the purpose behind the visit. They will look at ties in the UK, but also ties in their country of origin. And as your husband is married to you in the United Kingdom, and you share 3 children here in the United Kingdom, the entry clearance officer may come to the conclusion that this isn't a genuine visit for him to come to the UK, that this is just a way of him entering the United Kingdom because you can't enter under another route. In respect of the, you mentioned that you are on benefits. I touched upon this earlier. Although the requirement to sponsor a spouse, the financial requirement to sponsor a spouse is 18,600 gross per annum, that there is an exception to that if an individual is receiving certain types of benefits. You mentioned that you care for your visually impaired daughter. I assume that you may therefore receive carer's allowance. That is one of the benefits that does exempt you from the 18,600 limit. And so you can rely on that and instead show that you have adequate maintenance. The test is slightly different in that adequate maintenance simply means that having paid your essential living costs, such as your council tax, such as your rent or mortgage, that you have a disposable income, a leftover income, or that's equivalent to income support levels for a family. And so as long as you can demonstrate that the financial requirement would be met, you wouldn't be meeting the 18,600. If you could just send me a follow-up to explain why your husband is actually banned from the United Kingdom, that would help. So I hope that gives you some guidance in respect of the question. I appreciate that there is an element that I've not been able to touch upon, but I would need some further information before I can address that. Right, so we have some further questions here. If you just bear with me a moment and I'll just bring that up on my screen. So the general theme of this evening appears to be one around immigration and particularly partner and spouse rules. We have had a couple of questions around visit visas, and as I said earlier, they can be quite difficult unless they are properly prepared and supported with the relevant evidence. Main thing is that you are addressing the concerns of an entry clearance officer, that you are not going to go back, and that this is just a way of getting into the UK. Right, so in terms of the last question, that there was an element of the question which I'm going to, although I can't address directly for the person who asked the question, but I will address more generally, and that's in relation to the a 10-year ban. And again, any advice in respect of this is do consult an expert. If you do find yourself in this position, that there are ways of challenging these bans if it has been imposed, but certainly a detailed immigration history and information will need to be taken, which I don't have the remit for, unfortunately, in this particular programme. Now, in terms of the 10-year ban, there are provisions within legislation which allow for, and immigration rules which allow for individuals to be banned. There are different levels at which the Home Office will consider. There are, for example, mandatory bans, which they will almost apply where applicable. But there are also ones where the Home Office has a level of discretion. With regards to the mandatory ban, it's usually where false representations have been made to the Home Office, either by saying something that's false, writing down something in an application form that's false, providing false documentation, and even the non-disclosure. I think a lot of people are rather confused by this, but not declaring something that one should rightly have declared can be seen as a reason for a mandatory 10-year ban under the rules. And so it's important to know which category an individual has been or is alleged to have breached, and for the imposition of this ban to take place before one can unravel the process by which to then try and get this ban lifted. So just going through the requirements in terms of the reasons for imposing the ban. There is another one as well that people often miss, and that's a failure to cooperate with any inquiries that an entry clearance officer may want to make. So again, that could lead to an imposition of a ban. It is upon the entry clearance officer to produce positive evidence before they are rejecting the application. So they can't speculate that something may or may not be false. It has to be proven that either you lied or provided false documents, and there has to be evidence for doing so. If the entry clearance officer fails to produce that evidence, then they cannot impose that ban. And again, this is something that would need to be looked at where the ban has been imposed. With regards to discretionary bans as well, I will cover those on the other side of the upcoming break. As always, with a reminder that you can ring in and speak to me live in the studio with any questions. Alternatively, please send your questions through WhatsApp, and I will address them as fully as I'm able to on the other side of this break. Assalamu alaikum and welcome back to the last segment of the Free Legal Advice Show on British Muslim TV. I am Riffat Hussain and I am with you now for this final part of the show. Thank you so much for everybody who has participated in the show so far. I do have some more questions which I will immediately move on to, but if you do have any questions that you wish to pose, please ring the studio either on the landline number at the bottom of the screen, or send through a WhatsApp message on the mobile number you also see on the bottom of the screen. I was addressing a question just before we went to break from a sister who asked in relation to her husband's immigration application. He has been banned from the United Kingdom for a period of 10 years. And she clarifies that the reason why the ban was imposed is because he lied on the application form with reference to a question about whether or not he had made any previous applications. the sister says that he accidentally, whilst completing the application with his father, ticked no. It hadn't been his intention to lie on the application, but they hadn't checked it thoroughly enough to pick up the mistake. Unfortunately, the onus is on the individual who fills in the application form to ensure that the information is accurate, and so that it is checked and double-checked and triple-checked before the declarations are signed to ensure their accuracy, because the implications are, as you are now experiencing, quite drastic in certain circumstances. The Home Office or the Entry Clearance Officer's position in regards to this will be, well, the reason why he failed to declare a previous failed application is because he wanted to hide the fact that there had been a previous failed application. Rightly or wrongly, that will be most likely the interpretation that the Entry Clearance Officer has taken and has imposed this ban, rightly in accordance with the immigration rules. It's a mandatory ban if you provide false information, and false information, unfortunately, on this occasion, albeit inadvertently, mistakenly, has been provided, and therefore that ban has been imposed. It doesn't say in your question how long it's been since this ban was imposed, but your husband is able to appeal this after 10 years. That's the position, unfortunately, you do find yourself in. So I am sorry that that's probably not the answer that you're looking for, but unfortunately it seems as though the mandatory ban is correctly applied because there was false information within the application presented. And, it sounds very unsympathetic, and I appreciate that. But as lawyers, we come across this on a regular basis, where individuals undertake activities which they feel they are competent in, and then make mistakes that have really serious consequences for their future. And therefore, I always suggest, please do seek legal counsel before making any kind of application. Even if you've prepared the application yourself and you're satisfied, you may want to ask somebody to have another look, so that you have that expert view on has the form been filled in correctly, for example, have you attached the right documents. So there are document checking services and certainly application checking services out there. Please do take advantage of them, because it does prevent heartache like this in the future. But I do wish you well, sister, and I hope that there is some kind of resolution to this for you. So moving on from that, we have another question in relation to a visit visa. What kind of documents, I'm asked, can you present to show intention? It varies from a case-to-case basis. No two cases are ever the same. And the kind of documents that would usually help are documents that set out the applicant's financial position in their country of origin. So you may have bank statements, you may not. Bear in mind that many parts of this world don't work on a banking system as we do in the West. But there may be other ways of documenting any wealth and any assets, statements, for example, property documents, things of that nature still are evidence, albeit maybe not as strong as independent bank statements. But the Entry Clearance Officer will recognise that certain countries don't use banking, and there isn't the same banking system. Relationships can be another one. Does the applicant have a young family or a dependent family? Again, provide evidence, particularly if there's children. You can provide birth certificates. If there's a wife or a partner, there'll be marriage certificates. Again, and if the partner and the spouse is remaining back in the country of origin, then there's only so long that the couple are going to be separated for. And so one can then demonstrate that there is an incentive for them to go back to their own family. and not to remain in the United Kingdom for a prolonged period of time. Things like immigration history can be relevant. If an individual has travelled previously and abided by any restrictions, conditions, has left as and when required, then that again can be quite persuasive to say, well, there's no reason why it would be any different on this particular occasion. So there can be a number of things, but as long as one can demonstrate ties to the country of origin through various forms of documents, and bear in mind, where there is an absence of those formal documents, think outside of the box as to what else may substitute those. As I say, statements from individuals. Usually, statements from immediate family will carry little weight. The entry clearance officer may think that they are self-serving. Of course, your family member who wants you to shift to a Western country to earn lots of money will support you. So think about other people, elders within the community, ministers of religion within a community, councillors, politicians, anyone who is in a position of authority and who's not directly linked to your immediate family, and who doesn't have an incentive in you moving abroad, would be persuasive evidence. And again, likewise, provide details of the trip to the United Kingdom. What's the purpose? Are you coming for a wedding, for instance? Is there evidence of this wedding taking place? When will it take place? Or, are you coming for another event, such as you may be coming to meet your new grandchild, or maybe coming to support your child with a new grandchild? The various scenarios, and again, as much evidence as you provide will help that. And it's just making the legitimacy of your trip known to the entry clearance officer, that they can be satisfied that it is. There are certain countries where visit visas are often refused, from particularly countries where there is some kind of political turmoil. Sudan, for example, comes to mind, where the Home Office may feel that individuals will not go back because there is insecurity. There are other countries around the world where there may be humanitarian issues why individuals may not wish to go back, and that then heightens the likelihood of the application being refused. Again, the more difficult the application, the more evidence you need to produce to persuade the entry clearance officer that you are a genuine visitor. So I hope that does help. There is no kind of exhaustive list of documents that you can produce, but the obvious things are the purpose of the trip, your ties to your country of origin, how are you going to finance this trip? And again, entry clearance officers will look at that in detail. If you, for example, earn £50 a month in your country of origin, but yet are going to be spending £1,000 on your UK trip for a period of 2 weeks, that seems slightly disproportionate, and the Home Office will, or the entry clearance officer will question that. Is it really legitimate that you are spending such a large sum of money to you on a 2-week trip, and for what? So again, it would depend on the circumstances that you're presenting to an entry clearance officer. Where are you going to be living? Sometimes particularly if you are visiting a family member and they are providing the accommodation, then you don't have any accommodation costs. If they are providing your upkeep, they'll provide the food and host you, then you don't have those extra expenses. And therefore, an initial trip that may seem particularly expensive is not as expensive as it may have seemed if you present the evidence. But then you need to present the evidence to show that they can do this. Do they have the space to accommodate you? If you have 5 family members living in a 2-bedroom house, well, where are you going to go? So maybe that's not going to work. If they are on a very low income or no income, then how are they going to support you in addition to the other family members that they support already? So quite a broad range of things to consider. But again, seek legal advice so that the application is tailored to your particular circumstances to strengthen the chances of it succeeding. And so if you do the application yourself, then look for an application check-in service to ensure that you've had that secondary glance over it and you've had the advice in respect of the documents as well. I hope that has helped some of you in preparing applications that you may be considering in respect of either spouse applications, family applications, or even visit applications. As always, please do send your questions through. I'd love for you to call in and speak to me live in the studio. The contact telephone number is the landline number at the bottom of your screen. If you do wish to remain anonymous, then please do send through messages on WhatsApp. Please do just ensure that you do provide sufficient information within your message for me to establish what the facts are and what the question is so that I can address it directly for you and I'm not having to then give general advice. We are coming to the end of this show. I do thank you all for taking part today and I look forward to coming back next week and answering any further questions that you may have. Thank you so much for watching. Assalamu alaikum wa rahmatullahi wa barakatuh.